Hello friends, welcome to my channel. It's a girl Mercy. In this channel I talk about law practice, tips for excellent practice, the life of a lawyer, and all the pertains to practicing in an effective way. So today I'm going to talk about how to move a bail application. Bail application is one of the briefs both a young lawyer and old lawyer will usually get in the course of practicing law. Now you have to understand that we have different types of bail. You have the police bail, which is obtainable at the police station at the time when a person is arrested. Now, most times when a person is arrested, pending investigation or after investigation, the police can grant bail. Now, that you, as a lawyer, you meet the DCO or the DPO, depending on who's in charge there. Then discuss with the person. Most times, in Nigeria, my beloved country, we say bail is free, but we know that it's not always free. Then a shorty who will come to bail, the person will come with his or her identification, details and address. Then the bail will be perfected at the police station. Now, when you come to court bail, when the police must have charged a person to court and the suspect is now brought to court. Now, at the magistrate court, which is the court of summary jurisdiction, you see that when the suspect is brought to court, his plea is taken, then a bail application will be, raised by the lawyer that is to appear for him. Now, you know that the way bail applications are done at the magistrate court differs from the way it's done at the high court. The magistrate court, being a court of summary jurisdiction, bail applications are only done. While at the high court, you see that you have to file an application, wherein whatever point you're canvassing, why the person should be granted bail, will be contained in your application. Now, when a suspect is brought to the magistrate court, you have to announce appearance like in normal court session. Announce appearance. You are for the accused. The prosecutor will announce for the state or for the police, depending on the circumstance. Now, the charge will be read to the suspect, who will either plead guilty or not guilty. Now, the registrar will ask the suspect whether he wants his matter to be tried at the magistrate court or he wants it to go to the high court. It's obtainable here in Lagos and all over Nigeria, I know. The suspect will now say, okay, I want my matter to be tried here. Then that will be noted by the magistrate. Then you as a lawyer who is for the accused will now have to stand up and move a bail application. In this instance, it's as simple as saying, Your Honor or Your Worship, depending on your jurisdiction, I apply for the bail of the accused on most lenient terms or liberal terms. Just as simple as that. Now, but as a lawyer with distinction, as a lawyer who is practicing with excellence, with a touch of excellence, you can add that the offense for which the suspect is being brought to court is a bailable offense, and that the court has the jurisdiction and to grant bail to the accused, and that in so case, there are plethora of cases that the Supreme Court or the Court of Appeal have held, or the court have held that bailable offenses, the bail should be granted to the accused persons in bailable offenses. You can cite those cases just to add a touch to your application, to the application you're moving. But this is not a time for you to go to the merit of whether the accused is guilty or not guilty, in as much as the accused must have pleaded not guilty. Now, it's not one for you to go into whether he committed the offense or he did not commit, or what the police did or what the police did not do. Just apply for the bail, and that ends it. Now, when you have after you must have applied for the bail of the accused, the magistrate will not ask the prosecutor whether he's opposing. Sometimes, and most of the times, the prosecutor will always oppose the bail application. Now it's not left for the magistrate to make a ruling wherein either he is granting the application for bail, you state it then in stating the conditions that must be satisfied before the accused can be left, can be granted freedom via bail. Now, if as a lawyer to the accused, if you still have the instruction to perfect the bail, that would be beautiful. Then you have to prepare the bail bond, wherein the details of the surety, address, and all of that will be contained there. Then you prepare the surety for interview. The magistrate will have to interview the surety to be sure that this person is depending on the conditions of bail, is related to the accused and is available where the accused joins bail. Because the liabilities of a surety must be expressly stated for the surety to understand what he or she is entering, because there's a liability for the surety. Now, also in the interview, this is where the magistrate will ask the surety his address, his relationship with the accused, how he's related to the accused, whether he knows what standing as a surety means, and all of that, to ascertain that this person is not a fake or a horse, like someone who just, though there are sometimes you see people standing for surety for people they don't know, but the essence of the interview is for the magistrate to understand the relationship and to be sure that this person understands what he or she is about to enter. Now, after that, the police will be asked to, or the prosecutor will be asked to verify the address of the surety to ensure that the address stated by the surety is actually the address of the surety. Because when the accused joins bail, the next person to call is the surety, and if the address is not verified, then that will be a problem. So after the prosecutor must have verified the address, we'll let the magistrate know I've verified the address and it's okay. I can ascertain that this person lives here. Then another conditions must have been, the conditions of bail must have been satisfied, which if it's in Lagos, it includes that the surety must be a taxpayer, must be up to date, have to go and pay his tax, or if he's already paid his tax, he'll bring his tax clearance certificate to show, or the receipt of payment to show that he has paid his tax most times in the last 3 years. Now, when all this has been done and the magistrate is satisfied that the condition has been satisfied, then a warrant of release will now be signed, where you as a lawyer or the relative of the accused will take to the prison. Then the accused will be released. Now, that is released does not mean he does not have a criminal case pending. He just released so that he can be freedom to enable him to come to court and attend his matter, and do other things. Now, do not be a lawyer who encourages his client who is accused to stay away. You see an accused person, he has not been, though he's still presumed innocent, but always encourage them to be available for their trial. Now, if for any reason the accused will not be in court, you should be able to write a letter to the court, or if he's on health ground, produce a backup letter from the hospital stating why he was absent in court, because most courts don't take the levity. If you are absent in court once or twice, the prosecutor will apply for the revocation of the bail, and once the bail is revoked, the person will be arrested. Or if the person is not available, the surety will be arrested. So as a lawyer, you must be able to explain to your client all this. Now, most times you see, after the bail has been perfected, you start seeing people coming to let's settle and all of that. But that's another different video I'm going to do, about settling a criminal matter, if it is legal, and all that pertains to that. So you as a lawyer must be diligent and must carry out your duty professionally. Now, I will just touch a little bit about the charge and bail lawyers, as people call them. These are proposed lawyers who are basically in the magistrate court, looking out for clients who they will apply for their bail and probably perfect the bail. So that's what the term charge and bail means. These are lawyers who are always in court, magistrate court, looking for, chasing around for briefs, for perfection of bail, and if possible for applying for the bail of the accused. But whichever way, bail application either at the police or at the court is one of the briefs a lawyer will always face in the course of his or her profession. So you must know how to do it and do it well. Please watch out for my next video, where I'm going to talk more about the liability of a surety and the likes. Please, if you're a returning subscriber, I appreciate you. I appreciate you. I appreciate you. But if you're new here, please subscribe to this channel, like this video, and share it, because I know the information being given here will help you and help the next person, your neighbor or your friend. You never can tell. Thank you for watching this video, and I hope you understood what I said, and going forward you have more knowledge on bail applications. Thank you very much.